Well, our speaker today is a HASP member. She is a coordinator for the Social Sciences Committee with me and others. And now today she is going to be giving a presentation to you, and you know it's called the third branch, Current Issues Facing the Judiciary. It is often referred to as a third branch, and it plays a critical role in our democracy. Retired Judge Kathleen Kennedy will take a close look at several important third branch issues. Specifically today, we'll consider judicial selection in states, that's including Michigan, and the federal system, the pros and cons of appointing and electing judges, and term limits for judges, and the financing of judicial elections. Our speaker was elected to the Circuit Court of Cook County, Illinois in 1996 and served as a judge for 20 years. Previously, she was a law clerk for both a state appellate judge and a federal trial judge, and she worked as a government attorney representing abused and neglected children. And she has a degree in law, or a JD, from Northwestern University. And I am asking you to help me welcome Judge Kathleen Kennedy.
Thank you, Kit. Thank you very much. I thought of having Kit just have me walk out and Kit say, "All rise." So I'd be in a familiar situation, but it has been almost 10 years since I retired. So I guess we'll stick with this. And also, I'm not used to a microphone. I never had one in court. And I had a gavel. And I like to tell my grandchildren that I never once used it, because I learned that when you want to say something important or you want someone to stop talking, you just get very, very quiet. And then they have to listen. Anyway, so thank you for being here. I really appreciate it. It's a really interesting topic. Thank you. I have to say thanks to Amy and Hannah, because if they didn't help me, I wouldn't be here at all and you'd have an empty screen. Okay, so to begin, you have to bear with me. I've never done this before. So, and I never was a judge before I took the bench. I feel almost as nervous. Okay. So why the third branch? I mean, it could have been the first or the second. And, you know, I was looking at pictures of trees. I wanted to put a nice picture of a tree here with 3 equal branches. And I don't think trees ever have 3 equal branches. But anyway, I couldn't find one. The one I did find that I liked was too political to use. But, you know, the third branch, Baron de Montesquieu, was a great influence on our founders. And he believed there should be 3 different branches of government, and our founders decided to make them 3 equal branches. And I think that's a challenge. So the judiciary was intended as an apolitical, independent check on the power of the elected legislative, which is Article 1, and the executive, which is Article 2, those branches of government. So it just makes sense that the 2 elected parts, the legislative and the executive, are first and second, and the third branch, the judges, come third. And I think the thinking was that, you know, Congress ranked first among the equals. I mean, and the executive was there with the equals. And the judiciary really comes in last, because they're the ones that the plan was to check the other 2 branches. Just here a second. Oops, sorry about this. It's just the scrolling part that I'm not sure of. Here I go, I think. Yes. I knew I'd have some kind of technical problem. Thanks, Amy. Okay, that's it. What did I do there? Okay. Okay, just that. Oh, okay. Just press that. Okay, thank you. Okay. Okay. Now. Okay, here's our Constitution. So you can just see what the plan was. And I think it's important to point out that as Thomas Jefferson said, or as the Declaration of Independence says, one of the reasons we wanted an independent judiciary was because the kings the king made his judges dependent on his will. That's in the Constitution. So we didn't want that. So they came up with the plan. There wasn't a lot of dissent to have judges appointed by the president, by the executive, with the advice and consent of the Senate. Okay, now I got it. They believe that the judicial branch would actually be a check against the suffrage of the people. And at the time, they weren't really into the people voting. It was more, I mean, we did have this democracy, but they didn't ever talk about the people voting for the judges. And so there wasn't much dissent. And you can read all about this. I found these amazing websites that will give you all a lot of information about the early debates and so on. So we have, under the Constitution, we have federal judges who appointed through a selection process with a term limit, which is good behavior, and a salary requirement. So elections are just not an issue with federal judges. And so when we talk about Article 3 federal judges, that's because they're authorized under Article 3. It means they're there for life. There are other kinds of judges, which we'll see in a minute. So what's not in the Constitution, interestingly, is there are no qualifications for federal judges. The judicial system is not organized in the Constitution. The number of Supreme Court judges is not in the Constitution, and the number of courts. And interestingly, judicial review, which means the judges review the constitutionality of acts of the other branches, that's not in the Constitution either. That was judge created. So now let's take a look at the federal judiciary, and we might as well start at the top with our Supreme Court. So I don't know, I did want to say that I think one of the reasons everybody's here, or that it's a popular class for some reason, is because judges are in the news all the time these days. I mean, every single day I get I've had notes, I've been keeping notes for this class for a long time, and judges are in there every day, either a decision, or someone's complaining about a judge. And judges really, honestly, most judges, probably almost all judges, really prefer not to be in the public spotlight. They'd really rather just be doing their job. They would just rather be in their chambers doing their job, whether it's them making a decision by themselves or with, 2 others, or in the Supreme Court with 8 others. I mean, it's just not in the judges' you view to be out there in the public eye. And I think if a judge gets a high profile case, I mean, you go, oh no, so I know in this first month I was on the bench, I had a case about whether a known sperm donor could be declared the father of the child under Illinois law. I mean, the first month I was on the bench, it was a high profile case. They were courtroom drawings of me, and it was really scary. Anyway, so back to the Supreme Court. So I'm just going to talk a little bit about them because we hear about them all the time, and I don't know, I mean, you can look them up. You might know a lot about them, but I just wanted to go through, who appointed them and what year, how long they've been on the bench, on the Supreme Court bench, how old they are. And I'm also going to add their religion, because people have written articles about how skewed the Supreme Court is in terms of religion, and how it does not at all represent the makeup of the country. And also people have talked about how there are no nuns on the Supreme Court. And I don't mean the nuns that taught me. I mean, there's no people who identify as nun when asked what their religion is. Anyway, so Justice Sotomayor was appointed by Judge Obama in 2009. She's been on the bench for 16 years. She's 71 and she's Catholic. Judge Thomas was appointed by George H.W. Bush in 1991. He's been on the bench for 34 years, and he's 77 years old, and he's also Catholic. Justice Roberts, Chief Justice Roberts, was appointed by President Bush in 2005. He's on the bench for 20 years. He's 70 years old, and he's Catholic. Justice Alito was appointed by President Bush in 2006. He's been on the bench, the Supreme Court bench is what I'm talking about here. He's been on there for 19 years. He's 75, and he's Catholic. Justice Kagan was appointed by President Obama in 2010. She's been on the bench for 15 years. She's 65 and she's Jewish. Now in the back row, we have Justice Barrett, who was appointed by Judge Trump in 2020. She's been on the bench for 5 years. She's 53 and she's Catholic. Justice Gorsuch, appointed by President Trump in 2017. She's been on the bench for 8 years. She's 58 years old. He's 58 years old and he's Protestant. Justice Kavanaugh, appointed by President Trump in 2018, on the bench for 7 years. He's 60 years old and he's also Catholic. And the last and most recent appointment is Justice Jackson, appointed by President Biden in 2022. She's been on the bench for 3 years. She's 58 years old and she's Protestant. So you can see that there are a lot of Catholics on the Supreme Court bench, and it doesn't represent reflect the makeup of our country. Now, whether that's good or bad, whether that matters, I find it interesting. So in a recent article, journalist Linda Greenhouse discussed how she changed her position about indicating what president appointed a particular judge. So, I mean, when you're reading a news article, it usually says, like Judge Cannon, Trump. You can see who appointed the judge. And she thought that was really wrong in the beginning of her career as a journalist. She thought that was wrong because then it makes judges seem even more political it just makes them seem very political. Like it's just so you know what they're going to do because you know who appointed them. Now, whether that's the case or not, she thought it was wrong to do that. But now she says, and this is going to get a little bit political, but she says that identification of these judges by party label at this time, when only the federal courts stand between democracy and autocracy, provides essential reassurance that the rule of law is not a partisan project. So she will now believes that it's important to show who appointed the judge, because you may learn that they aren't doing what you would expect them to do, or you may learn that they surprised the president, that they may be surprising the president that appointed them. In fact, the same journalist, Linda Greenhouse, wrote the obituary for a retired Supreme Court justice who died recently, which is Justice Souter. And he was a Republican appointee, and he allied with the court's liberal wing. And apparently, according to Linda Greenhouse, Republicans said, no more suitors, no more suitors. We want judges who are going to align with the philosophy that we chose them for. Now, the federal judiciary is way more than the Supreme Court. There's only 9 of them. There are a lot of judges in the federal courts. Now, I just want to let you know that the terminology for judges in courts can be confusing. So in the federal system, the circuit courts are the appellate courts, the courts of appeals, and in the district courts are the trial level courts. In Michigan, the district and the circuit courts are both trial level courts that just handle different types of cases. And I should have said this at the beginning. I'm going to put online, or not pass out, but anyway, you will have access to a complete list of resources and sources. Like I've read so many great sources and I want to share them with you. And this is a lot of information. Some maybe you might want to have. So anyway, there will be a full list after session 2. Okay, so Congress decided about these courts, and in 1789 with the Judiciary Act, and established, as you can see, 1 Supreme Court, 13 circuits, and I have a nice map here. Okay, so there's federal districts and circuits. Michigan, I don't know if you can see it, but there's a little dotted line right kind of down the middle, which makes the Western and Eastern districts of Michigan. So the U.S. District Court for the Western District of Michigan has courts in Grand Rapids, Lansing, Kalamazoo, and Marquette. We have 4 active and 2 senior district court judges serving the Western District of Michigan. And senior status is when judges have met age and years of service requirements, they can keep working with their full salary and a reduced caseload. So that we have 2 senior judges, I believe. And then there's magistrate judges. Now, they are not Article 3 judges. That means they don't have life tenure. They are selected by a committee and voted on by the circuit court judges, the district court judges so our magistrate judges here in the Western District of Michigan would have been selected by the district court judges in Michigan. There are also bankruptcy judges. They also are not life tenured. They are also selected. So I know I'm giving you a lot of information because it's sort of the background for everything we're going to continue talking about. It's a little bit dry. Okay. So the federal appointment process for U.S. Supreme Court justices usually gets lots of publicity, but what about the lower ones, the lower courts? So it's the same process, a nomination, confirmation, there's hearings, and a Senate vote on the nominee. The nominees are usually recommended by legislators. Usually the senators in the state will nominate for a vacancy in that state. And the senator of the president's party was the one who will nominate when there's a vacancy. Anecdotally, when the senators, one's a Republican and one's a Democrat, they'll agree on a candidate. So that's how it works. There's a source I'm going to give you that has lots of detail about the whole procedure in the Senate, and it's interesting, but it's a lot. Okay, let's see, what did I do there? Okay. So like I said before, there are no qualifications for federal judges in the Constitution. So the United States Court's website lets us know that they have developed, the Congress and the Department of Justice, which review the qualifications, have developed their own informal criteria. Now, informal criteria kind of scares me because it sounds kind of vague, but so there's an article that discusses what those are, including a philosophy acceptable to the president and a general acceptability to the president's political base. So there are other criteria that have been used. The American Bar Association used to be very active in vetting the nominees, all federal court nominees, and I have it on the screen, they would rate them on integrity, professional competence, judicial temperament, and not philosophy, not political affiliations, or not ideology. Now, and wanting at least 12 years experience in the practice of law. Now, effective in June 2025, the Attorney General let the ABA know that a couple of Republican administrations have restricted the ABA a little bit, but now as of June, the ABA is treated like any other organization, any other interest group that just wants to let the senators know what they think of the nominees. So they used to participate and rate them well qualified, qualified, or not qualified. But there have been allegations of bias over the years, which you can find studies that say, yes, there's been bias, studies that say, no, there's been bias. The ABA, of course, said that 96.9% of the rated nominees in each administration during the last 20 years, including the first Trump administration, were rated qualified or not qualified. I was kind of interested to see, were rated qualified, sorry, no, not qualified. And there are sources that will let you know which judges how they were ranked. I took a look at Judge Eileen Cannon. I don't know if you remember her name because she received a lot of negative press for being, for just ruling. She was appointed by President Trump, and she got a lot of bad press for maybe siding with him and doing what he would want. And she was rated qualified. She met the credentials, so it wasn't, I was wondering if she was rated not qualified, but she definitely was qualified, and she has very impressive credentials too. Okay. This is a very complicated view of the interaction between the federal and state court systems, which I just thought you might want to have it because with paying for the class, it might be worth the $5 just to have this thing. But I'm not going to go through it because it's proof. But I just thought it is interesting. It's very detailed, and we have these two systems, and it's complicated. Okay, so let's turn to Michigan. So like the federal system, the story begins with the Constitution and the Michigan Constitution. And I don't know if you like reading constitutions. Maybe if you can't fall asleep, you might like them and all that legalese. But I did read that Montana has a non-legalese constitution. We don't. So Michigan's had 4 constitutions, which isn't unusual. The election of lower court judges began with the 1835 Constitution and was considered very democratic at the time. Our most recent constitution is the one we're working with now, is the 1963 Constitution. Also, it's kind of interesting in Michigan that the judges run nonpartisan, except the Supreme Court judges, the Michigan Supreme Court judges, participate in a primary. And there was a challenge to this. A group decided that, or thought that this was not, it kind of didn't do well for the concept of independent judiciary. So they brought a challenge, and the Michigan Supreme Court said it was okay to have the Supreme Court judges nominated out of a primary, like a partisan primary. So you can, anyway, those are constitutions. And like I said, if you like reading them, fine. So there are some interesting facts about constitutions. There's only been one US Constitution, which has been amended 27 times. Massachusetts is the only state with that's only had one constitution all this time. And every other state has had at least 2. They're longer than the federal constitution because they have, states have plenary power and not delegated power. And so they have to have more detail. And our constitution, Michigan's, has about 20,000 words, which is about the national average. Now, this is a really interesting thing that I did not know. Every 16 years under the Michigan Constitution, there's an automatic ballot provision asking whether to hold a constitutional convention. So this question will be on the ballot in November of 2026. You might want to think about it. I mean, the thought of a constitutional convention is kind of mind-boggling in this, in the current climate. But also, maybe there's things when we talk about judicial elections, maybe there's things that should change. I don't know. But anyway, Michigan voters decisively said no in 1978, 1994, and 2010. So look for that on your ballot next year. Okay. Okay, now here you get to meet the Michigan Supreme Court judges. So we have, well, this is, I just want to point out, or I meant to say this earlier, that I have used AI in my research. Often the AI summaries that show up when you're looking up something. I often would also click on the little thing to look at the original source that's leading to the AI. And I found it very helpful, but I like checking it. And in fact, if I didn't check AI, I would be telling you that Michigan has 2 Republican Supreme Court justices, when in fact they have 1 Republican Supreme Court justice. And I also would have put a Texas judge in the Allegan County system. So AI isn't really exactly, gotta double check sometimes. Okay, so we have here, I'm just gonna tell you who they are and how they run in staggered 8-year terms, which is good, I think. I don't want to impose my own thoughts too much, but so on the bottom row from left to right is Justice Zara, and he is a Republican. In the middle is Chief Justice Megan Kavanaugh, and she's a Democrat. Well, all the rest are Democrats. Justice Bernstein is a blind judge. I think he's happy to let you know that. And on the back, we have Justice Thomas, Justice Welch, Justice Bolden, and Justice Noah Hood. Now, Justice Zara was appointed by Governor Snyder and then elected to a partial term. He was reelected in 2014 to a full term and reelected again in 2022. So his term ends in 2030, which is the same year he reaches the mandatory retirement age. So I meant to tell you that unlike life in the federal system, Michigan judges have to retire when they're 70. If they're 70 in the middle of a term, they can finish out that term. We'll talk about that more when we get to the question of term limits. Okay, Chief Justice Kavanaugh, her term ends in 2027. Oops. Oh, did I go backwards? Oh, I didn't know that would do that. I'm sorry. Oops. There, okay, thank you. Thanks for your patience. What am I doing wrong? Okay, Justice Kavanaugh's term ends in January of 2027. Justice Bernstein's term ends in 2031. Justice Thomas in 2033, Justice Welch in 2029. And Justice Hood was just appointed. He has never been elected. He was appointed by Governor Whitmer, and he has to win an election in 2026 to continue as a Supreme Court judge. So as you can, so the makeup of the court, the next chance to change the Republican Democrat makeup of the court will be in 2026 when recently appointed Justice Hood runs for election. So right now we have six Democrats and 1 Republican. Okay, you have this handout of the Michigan Judicial Branch. I'm not an expert on websites, but to me, the Michigan Court's website is excellent. And you'll get the site for it, or you can get it easily. You can get biographies of all the Supreme Court judges, and you can also go to the Learning Center, which is really interesting. It has games such as Balance the Scales of Justice and A Day in Court. It gives you information about tribal courts. And it also, I didn't delve into this, but it also has historical images and primary sources so you can learn about the 1937 Flint sit-down strike and the 1937 Battle of the Overpass in Dearborn. So it certainly gives the impression that the Michigan court system, the judicial branch in Michigan, wants everyone to get to know them and how they work and really be familiar and understand the system. So I was very impressed. Okay. Now, this is how the Michigan courts are split up. And I also have a slide about the pay for Michigan judges. So here are the names of our local judges in Allegan and Ottawa. We have in Allegan judges Antkowiak, Baker, Jip, Clearwater, Scosellis, and Burnett. And in Ottawa, we have judges Van Ellsberg, Hulsing, Engel, Kraus, Boccanegra, Bunce, Knoll, Mulder, and Dahlman. So one thing I want to throw out, did you vote for any of them? Did you know anything about them when you did? It's kind of a question that we'll get to again later. And how did you get the information that you got? Anyway, just speaking for myself, someone told me that they'd met one of them during a campaign stop and they liked her. And so I thought, okay, that's how I did my voting. Okay, so these judges serve in the circuit court, which is a trial court of general jurisdiction. Allegan's is the 48th and Ottawa is the 20th. And I know we may have members in other counties, but I only did Allegan and Ottawa. And then the district court in Allegan is the 57th and the Ottawa is the 58th. And this is a court of limited jurisdiction, civil suits over 25,000, involving 25,000 or less, adult minimum misdemeanors and landlord-tenant, land contract forfeitures, and all criminal adult proceedings begin here in the district court, regardless of the nature of the offense. The probate court is also a trial court of limited jurisdiction. It handles drain appeals. I don't know what those are, but maybe I should. And estate proceedings, trusts, guardianships, mental health proceedings, and other matters, including petitions for protective orders, civil actions when a trust, estate, or fiduciary is involved. So, like I said before, the Supreme Court serves for 8-year terms, and the other courts in Michigan serve for 6-year terms. So they can run indefinitely. They can be a judge for a long time, but they have to end when they're 70. Judges are well paid, though their salary is likely a pay cut if they came from like big law, or a pay raise if they came from a public interest. So, so all this information about their salaries is available to the public. So you can decide whether they're earning their pay. Okay. So one way to consider, or on our way to considering the pros and cons of judicial elections, I thought we could consider who wants to be a judge and why. So, I mean, it's important to wonder when we think about the qualities we want in a judge, we also want to think about who wants to be a judge and why. I have friends who say, lawyers would say, I'd never want to be a judge. I'd get too mad. I couldn't be fair. I just couldn't do it. I wouldn't want to listen. I wouldn't want to listen. So anyway, who wants to be a judge? So what I did was I wrote a letter to one of our Allegan County Circuit Court judges, Judge Emily W. Jip, and I asked her a bunch of questions because my story is different. Mine's from Chicago, and I wanted her to give you a Michigan story. So she told me I could share these with you, and I want to read them because I want her voice to come through because it's nice to know your judges, you know. So okay, so I asked Judge Jip. I'm starting to call her Emily just because of our email. Anyway, I asked Judge Jip, how did you make your decision to run for judge? So here's what she said. My father was an attorney. Growing up, I spent time in his office, filing and generally helping out. I always considered the practice of law when thinking of career options. Once I committed to law school, a long-term career goal was to be a judge. As I practiced law, that desire simply grew. When the governor created this third judgeship, it was generally believed the position would be designated as a family law seat. 3 individuals announced their candidacy, and shortly thereafter, it was announced the position would actually handle criminal law matters and divorces that do not involve children custody disputes. The anticipated caseload matched my work experience well. I looked at the candidates on the field, and I simply felt I could do a better job. Wanting to do something and then actually committing to a contested race are 2 very different things. There were many serious conversations with family and friends, conversations mostly about the financial and time commitment and whether we could make it work. I have 2 elementary-aged children, and I was worried about the time a campaign would take away from them. I prayed on the issue as well, and in a moment of, what the heck am I getting myself into, I asked God to give me a sign that I was at least on the right path. In that moment, I received a phone call that one of my competitors, who I saw as very real competition, was dropping out. I took that as a sign, whether I was going to get the position or not, I needed to run. So then I asked, did you have to obtain signatures to get on the ballot? Now, this is the signature requirement, yes. Okay, in Michigan, if you are not running as an incumbent, you have to collect signatures. How many you have to collect is based on your jurisdiction's population. In Allegan County, I had to collect 600 to 1,000 ballot signatures. You have to have at least 600 and can't submit more than 1,000 to try to hit that mark. I ended up turning in around 800. I collected signatures from everyone I knew in county, and since I didn't know 800 people, I spent most of March knocking on doors, introducing myself and requesting signatures. It was a good use of my time. I then made an effort to go back to those same neighborhoods after I won the primary to reintroduce myself. Familiarity increased the likelihood of a vote. Okay, and then I asked, did you actively campaign in the community? Oh, sorry, one more thing about collecting the signatures. So I started collecting signatures and introducing myself at the end of January, beginning of February. In March, I started knocking on doors on weekday evenings after work until around sunset. I had to have my signatures submitted by April 24th. I wanted to have them submitted by the end of March in case any were challenged and I needed to collect more. I collected enough signatures by the end of March to send them in. I took off spring break with my kids, and during that week, I was notified my signatures were accepted. My opponents did not challenge them. We could get into a little bit about challenging petitions, signatures. We'll do that in a minute. Okay, so then I asked her if she actively campaigned. Yes. Once I got over the hurdle of getting on the ballot, I would knock on doors from 9:30 to 5 or 6 on Saturdays with a lunch break in the middle of the day. and after work for several hours most days. I had canvassing data that I used to target frequent voters and chose what neighborhoods to knock on and based on largest number and concentration of regular voters. It was very clear that Allegan County had a lot of voters participate in mail-in ballots. The week or so before the primary, and then the week or so before Election Day, I would knock on doors only to be told the person had already voted. I thought that was very interesting. I went to every township, city, or village meeting at least once during the campaign trail and attempted to hit them all at least twice. There I would introduce myself and give a little stump speech. I walked in 4th of July parades, the Allegan County Fair Parade, the Fenville Goose Festival Parade. I rented a booth at the Allegan County Fair, took a week off work and manned my booth so I could meet as many people as possible. I went to political party meetings for Republicans and Democrats. I participated in a League of Women Voters candidate forum, and I participated in 3 meet and greets as opposed to fundraisers. I created a website, Facebook candidate page. I advertised on Facebook, appeared in a podcast, sent out 2 rounds of mailers, and even did, her words, a very cheesy commercial. I was very responsive to any emails or messages sent. So I asked her about her stump speech. And because judicial campaign speech is an interesting animal, we'll talk about it in a minute. This is just showing what she had to, how she had to qualify. So judicial campaign speech. I mean, what do we want to know about someone who's running for judge? What would you really want to ask them about? Do you want to know their political philosophy? Do you want to know their experience? I mean, what do you really want to know? As I think about it, I think I want to know their work ethic. And how do you ask them that? And would they tell you the truth? I want to know their integrity. And how do you find that out? And there's, I mean, everyone has an idea of what kind of judge they want and how you want them to act as a judge, and how do you find out so you can be an informed voter, at least while we're electing judges. So I asked Judge Jip about her stump speech, because there used to be a rule that you couldn't say, state court judges couldn't announce how they would rule on a case, which is a very good rule, because you don't want them saying how they'd rule if they haven't heard the facts or the evidence. And then the Republican Party of Minnesota brought a lawsuit that went to the US Supreme Court saying that campaign speech is free speech and it's entitled to First Amendment protection. And that's what the Supreme Court agreed with that on a 5-4 vote. So judges can campaign and speak, but they still can't really say how they'd rule on a case, but they can have campaign speech. It's kind of a tricky concept to me. Anyway, so I asked Judge Jip about her stump speech. So she said, my stump speech typically consisted of a brief rundown of my work experience. I also discussed my desire to work towards creation of a drug treatment court for felony level possession offenses. Methamphetamine is a serious issue in our county and has been for a long time. I'm going to abbreviate this a little bit. I'm currently the presiding judge of Allegan Treatment Court, working with MDOC and local service providers. We have built infrastructure for our program and are hoping to start taking our first participants this month. So she had a thought of what she wanted to accomplish as a judge. She told people about it when she was campaigning, and she's actually doing it now, which I think is amazing. Anyway, she said I routinely got asked very hot topic political questions. It was such a polarized election year with the presidential race. I tried to answer questions to the best of my ability without violating the judicial canons. So there are canons that govern the speech of judges, but there's also the case that says it's campaign speech is free speech. My stance on abortion was a very regular question. My response was that as a circuit court judge, I would not expect to ever address the issue. A minor can petition the probate court to seek a waiver of parental consent to have an abortion. Minors under 18 need one parent or guardian to consent to an abortion. If our elected probate judge who would be the judge handling that type of issue, was somehow conflicted out of the matter. So if he knew the person or something, he'd have to recuse himself. That would be the only possible time Judge Jip might get his case. So she explained that when she was campaigning. So this is the only scenario where I could be confronted with the issue, and it is highly unlikely. I made it clear that I would not have an issue hearing the matter because as a judge, I must follow the law. And if the petitioner's situation warranted the court granting permission, then I would follow the law. I then asked her about campaign financing. I raised money through a committee. The judicial code of conduct also applies to judicial candidates, and they prohibit a judicial candidate from accepting or handling any money. I had a treasurer, and members of my campaign committee will be at each meet and greet event in case anyone wanted to donate money. My campaign was financed by donations from family, friends, coworkers, members of my immediate community, but it was predominantly self-funded. So keep that in mind when we get to the question of financing elections. Okay. Now my story. Oh, yes, I did have brown hair at one point. Now I put the picture up because for a couple reasons. So, well, first of all, my story is way different from Judge Dipp's, except Cook County has sub-circuits. So I didn't have to run across the whole county, which would be huge. In fact, a judicial candidate was once heard to say that campaigning for a judge countywide in Cook County, going out and campaigning would be like peeing into Lake Michigan to try to change the water level. So it's pretty daunting, but my sub-circuit was small. It consisted of 3 suburbs. It was kind of gerrymandered and several wards in the city. So I only needed 500 signatures when I started. I'll tell the whole story, but I just want to point out on the slide that, so first of all, I did not really want to be green, and I turned out to be green. So it was not how I expected. Then you'll notice, I don't know if you can see it on the slide, very small in the one on the upper right is the union label, that it was a union that printed the very important union label to show the people that a union that you were, I guess, pro-union, not pro-union exactly, but that a union shop printed your literature. And then after these were printed, the Tribune, the Chicago Tribune ran there and did their endorsing. And so I had to buy a stamp because I was endorsed by the Chicago Tribune. My boss put in a good word for me. He said I was a cross between the Virgin Mary and Blackstone. I don't know how that helped the Tribune, and I'm certainly not a cross. But anyway, so anyway, they endorsed me, and I spent a lot of time stamping and spreading these things out. Now the ballot is interesting because it looks like one race, doesn't it? It looks like 5 candidates in one race. Well, actually, it's 2 races. It's 3 candidates in the top one and 2 candidates in the bottom one. Now, one of the common things that happen in Cook County is women with Irish names win. It just like happens. So I was running against Judge Barbara Riley. She's in the other part. And she noticed this. I didn't even notice this. She said, oh my gosh, we cannot use that ballot because they'll split up the 2 Irish names, the 2 Irish women's names, and someone else will win. So she got the ballot corrected so that it was clear, it was moved. So it was clear that Kennedy, Austin, and Ballard were here, and Riley and Smith were here. So anyway, so why did I run for judge? Not as nice of a story as Judge Dipp. When I was in law school, one of the professors said, well, if you get mainly A's, you'll be a professor. If you get mainly B's, you'll be a judge. And if you get mainly C's, you'll make a lot of money. So I thought maybe I wasn't really that interested in making money. I thought, put it in the back of my head, maybe judge would be okay. Anyway, Illinois judges, it's a partisan election, Republican and Democrat. The signature requirements for anybody other than a Republican or Democrat is impossible. You could never run as anything else. In Cook County, most of the, as you might know or expect, most of the county is Democrat, highly Democrat. So except for a couple parts of the county if you win the Democratic primary, you're going to win in March, you're going to win in December, in November. I needed the petition signed, just like Judge Jip did. Went around, got signatures. A lot of people don't want to sign those petitions, and I don't know how you feel about it, but it's generally, I would say it's important to get people on the ballot. It's kind of a good thing. I tried not to take it personally when they walked away from me or whatever. So now people told me, even though I only needed 500 signatures, that I would need 1,000 because, and we don't have, Illinois doesn't have signature limits like Michigan apparently does. So you could get 1 million and just so you don't get knocked off the ballot. And I got on the ballot. They didn't challenge my petitions, so that was good. So I learned on the campaign trail that the Cook County Democratic Party organization was backing one of my opponents, which meant his name would be publicized on all the party mailings and all the postings, and it would give him a lot of votes just on that basis. And then someone told me, we go to these events and people like talk. They told me that if I wasn't backed by the Cook County Democratic Party organization, I had a 4% chance of winning. So, but the Tribune endorsed me. So then I think my odds went up, and my name is Kennedy, which is kind of an electable name. And so despite the odds, I won the primary and I won in November. It was, like I said before, it was like the year of the women, and women with Irish names generally, I don't know why. I mean, I don't know why. Anyway, and the shenanigans like that, they continue because in 2010, a lawyer named Philip Spiewak ran for judge and lost. So in 2012, he formally changed his name to Shannon O'Malley, and he won. I mean, it's true. I mean, it's just totally true. He told the news media that it was not done to win extra votes. Now, Cook County, Illinois judges have to run for retention the trial level judges every 6 years, the appellate court and Supreme Court every 10 years. Now, Judge Shannon O'Malley was just up for retention, and they've started to really, this has changed a lot since when I became a judge. They started really publicizing everybody and giving information out, and he lost his retention vote. I don't think it was because of his name change. He didn't have a really good reputation anyway, but anyway, he's not a judge anymore. No, he's not a judge anymore. So my election story continues a little bit. It's different from Judge Jip because for three times I tried to win a seat on the Illinois Appellate Court. I ran countywide, and because it's countywide, you have to get a lot of signatures. And the first time, the signatures requirement is based on a percentage of the number of voters in the last election when a governor was running or something like that. So it was a lot. I've blocked out how many, and I couldn't find my notes. Anyway, so my first run, the Cook County Democratic Party organization put another Irish woman's name on the ballot. I sent mail out to my opponents and it came back undeliverable. So I don't know if she really existed. Anyway, so I didn't win that one. The second time, my opponent spent $500,000 against me. Whoa. And he had TV ads. I didn't ask anybody for money except family and friends. I used some of my own money. I never raised funds. So I couldn't compete with that. And he won that one. And the last time was my best shot. And I only had one opponent. And I made the mistake of buying signatures. You know, people go out and do them and then they certify them and everything. And some you can buy them because I was running low. Anyway, they challenged my signatures. A lot of them got thrown out. I had to have a hearing. I mean, I knew that I did a lot of those things, getting the petition signed. So I knew these were the people they said they were. And the process is where they look at the signature you signed when you registered to vote 20 years ago, and they compare it with the signature on the petition. And it's the clerk saying, nah. And so they knock off your signatures. So in this case, they knocked off too many of my signatures. I had a chance to rehabilitate them at a hearing and having people come and testify. And it got later and later in the cycle. And then I lost at the hearing. I didn't have enough signatures, but there was something they did that I thought was wrong. And so I was going to appeal to the circuit court, but time ran out. And so my name actually was on the ballot, but everyone who came to vote got a slip that said, if you vote for her, your vote's not counted because she's not really on the ballot. Anyway, so that's my very long election story. So judicial evaluations, like evaluations by bar associations, are very helpful. And I think as far as elections go, information does get out. And I think people learn more about the candidates. And also when there are, Judge Jip informed me that there's a Michigan interactive caseload database. So you can look at how cases are being, make sure judges, I guess it's an initiative to make sure judges are timely moving through their caseload and reduce one of the goals is to reduce wait times for court hearings. So there's a tracker for that. And I didn't know this, we didn't have this in Cook County, but Judge Jip says that every year we are also required to conduct a public satisfaction survey regarding referees and judges. And for a week, we have man tables and attempt to distribute surveys. And we provide QR codes so that residents can take the survey digitally. And Judge Jip adds, I'd be really interested to hear how other jurisdictions evaluate judges once on the bench. It seems like at least half the parties may be unhappy with your performance in a given case. So also now in the age of social media, people can post whatever they want about how you did as a judge. And I know I had a difficult case involving the mom wanted to move with her two sons to Texas. And she had fallen in love and wanted to marry a man who lived in Texas. And the kids had a really good relationship with their dad, who lived very close to them in Illinois. So to me, these were the hardest child custody kinds of cases. We called them removal cases. And it was a very hard case. And her husband in Texas, actually, it was before remote work. So maybe now it's not such an issue all the time. But her husband tried to have his company let him work in Chicago area remotely. But the data that had to come through was, what the company said no. So I ordered that the mom could move with the kids to Texas. And the paternal grandmother posted all this stuff about me online. She's divorced. She didn't. Anyway, so there's also that. So we have the evaluations by the bar associations, the evaluations of your performance, and then social media. Okay. So now that you've heard these judicial election stories, what do you think? Are you leaning one way or the other, elect or appoint? You've just heard about two fun election stories, but hold on to that thought because we're going to change the order of things and deal first with term limits. Now, one of my friends, a lawyer, said, judicial elections, pros and cons. It's an interesting question without a good answer. Now, term limits. Maybe it's an easier question, but I don't know. So as we discussed, there are no term limits for Article 3 federal judges. They serve for life during good behavior. And in our next session, we're going to talk about judicial behavior, codes of conduct, ethics, and that's coming next time. Currently, there's a question about whether the Supreme Court or any federal courts could have term limits. And because of the good behavior clause in the Constitution, many scholars are skeptical of Congress's ability to do that. However, let me just get my note on this. There's been introduced, it was introduced first in 2020. Let me get the exact term for it. The Supreme Court Term Limits and Regular Appointments Act. It was first introduced in 2020 and reintroduced in the House on February 6th of this year. So right now it's in committee. The plan or the proposal in that legislation, I haven't read it, but I just read a blurb that said it's 18-year Supreme Court terms, and then the judges serve elsewhere. So they're serving for life. They're just not serving for life on the Supreme Court. They could serve at the district court or the circuit court level. So I think that's how they're trying to work around the constitutional provision. Whether it will work, And whether it will happen, I have no idea. So of course, there's questions for the pros of term limits. So, you get old, we all know that happens. There's no confirmation issues and turnover. Now the cons are that it undermines judicial independence to have a term limit, because lifetime appointments are designed to insulate judges from political pressures and social currents. But like I said, there has been bipartisan support for term limits in the federal system. Chief Justice Roberts has weighed in favor of them, or he did at one point. Justice Kagan and conservative and liberal scholars are not against term limits. So I think the main concern is that lifetime appointments have led to more politicized court and decline in public trust. And as we know, public trust is essential. I'll just digress for a moment. And I just looked this morning to see, kind of gauge what the current public trust levels are in our courts. And right now for the federal courts, this was very recent Pew research, I think, if they're, see, these days you're always like, are they trustworthy? Is it fake? So anyway, Pew says that right now, as of September 3rd, its Supreme Court is half and half favorable and half unfavorable. It's at pewresearch.org. They go through a lot of detail on Democrats, what they think, Republicans, what they think. So, but right now it's 50-50. In 2020, it was 70% positive. So it's decreased a lot. And really, I mean, we all know how important it is to trust the courts. It's very, very important. State courts are doing much better. In December of 2024, this was only based on 1,000 registered voters, so I don't know, but it was 63% confidence in the state courts. So like I said, anyway, you can ponder why that is. Okay, so so now the question is, so moving to Michigan and many states, they have age limits. The term limit isn't really a term limit per se, but an age limit. So in Michigan, it's, as I said, it's 70. I wanted to back up for a second and talk about a federal judge, 98-year-old Judge Pauline Newman of the U.S. Court of Appeals for the Federal Circuit. I don't know if you read about her, and she gets some press. So she's 98 and still working. Well, she was trying to work, but the committee, the Judicial Council, took her off the bench, and because there were signs of cognitive decline. I don't know, 98, maybe. Anyway, so she is suing. She says she has a constitutional right to work, to have a lifetime of work. So she's there, she's still getting paid and everything. So she's still doing her lifetime, but she's not working. So she's making a claim that she has a lifetime guarantee work. So far she's lost. And she says, she told Reuters, the issues of judicial independence that are at stake here seem to loom larger and larger with each decision adverse to me. So I don't know, I suppose the case will end sometime. Okay, so Michigan is 70, which to me sounds too young, but that's what it is. Now, because it's constitutional, we don't need to spend time discussing it really. If you want to do a con, you could try to change it maybe, but that's a whole big thing. Now in Illinois, I just have to tell you what Illinois did. In Illinois, it was 75, and it's the same thing where you could finish out your term. If you were 75 at the very beginning, you could finish out your term. So conceivably, if you were on the Illinois Supreme Court or appellate court, you could, be 74 and work till 84 or whatever. So one of the judges didn't like this. I guess he wanted a lifetime appointment. So he sued, and he won. So he went to the Illinois Supreme Court, and in a very, very complicated decision, very up and down kind of constitutional analysis, they said that the Illinois law that required mandatory retirement 75 was unconstitutional. So now Illinois judges can work forever too. So now that we've discussed term limits, we will move to appointments versus voting. This is how states select their justices. This is put out by the Brennan Center, which is a resource that I've used a lot. Some would say, you know, they rate these resources on how they are. I guess it's not a conservative group. It's nonpartisan, but it's not a conservative group. So this is a picture. I don't know how well you can see it. Of partisan elections, nonpartisan elections, gubernatorial appointments, a merit, retention, legislative appointments, and a hybrid. I mean, it's interesting to see that it's New England that basically stayed with the same appointment approach. So in the I think it was 1812, Georgia became the first state to use elections. And it became kind of a wave of popularity. It became very popular to start electing judges. So that's how it began. This slide has more of the details on the different types of elections and the different types of judges and how they select their judges. Okay. So the pros and cons. Okay, setting aside the issue of money, which will be our last topic this session, we can consider the other pros and cons. Like, so I think when we're talking about judges, we're talking about independence versus accountability. I mean, that's how it's phrased. And independence is going to be a big thing next time because it's subject to different definitions, and it's been different throughout history. But I guess basically we're looking for judges who are independent. So does an election give you a better chance of having an independent judge? Like I said, the appointive system was the clear preference in all of the 13 original states. And that's why in the map, you could, well, go back to the map for a second. That's why in the map, you can see that it's the 13 original states that still have appointments. So again, it was Andrew Jackson's presidency that saw a shift away from judicial appointments towards judicial elections. And judicial accountability took over the competing interest of judicial independence. And every state entering the Union after 1832 adopted constitutions that provided for judicial elections. So, so are judges who are elected more accountable to the people than because they are voted on, and they can be voted out too. I mean, so there's a recourse for bad behavior if they're elected. You can't vote out appointed judges. Suppose, are they more independent from the other branches? Well, they're not beholden to a particular leader who appointed them. So they're not beholden to a particular governor or senator or president. Maybe an important question is whether there's more diversity when there's elections. Like I mentioned, in Cook County, they have a sub-circuit system, and the goal of that system was to get more diversity on the bench. And I remember when I was working in juvenile court long ago, it was all white judges, and many of the kids that you were dealing with, taking away from their parents, were Black. So it was very, you know, I mean, I think perception is important and diversity is important. In fact, there is a Michigan DEI initiative in the court system. I hope by next time I'll have a follow-up. I was going to follow. Nothing's happened on that site since 2023. So I was going to follow up. It has a contact person. I'm going to follow up with him and see if anything is still going on as far as diversity in the courts. Another possibility, which is that elected judges, stimulates debate on important issues through judicial campaigns. But I don't know. I'm not really seeing that. I mean, do any campaigns really seem to deal with important issues these days? They seem to be more drama and personality, and I think that might happen with judges too. I mean, it sounds like Judge Jip's perspective would be she really did talk about issues. I mean, she was out there telling people that she wanted to do this special kind of drug court. So, I mean, that's important. And she couldn't do that if she was an appointed judge. I mean, there's no way that could be information provided. So I guess public awareness, the public being informed. I mean, that's much better than it used to be. I mean, like with social media, like I was talking about, you can really learn a lot about the judges through the Bar Association evaluation, the candidates, I should say, through the Bar Association evaluations, through their own material, like at campaign events. But I guess I always still wonder what do you really get to know? And is it a sense of the person? I don't know. It's tricky. So another thing is, and this comes from an article that Linda Greenhouse, who I mentioned before, wrote about. Her article is that Sandra Day O'Connor was wrong about elected judges. So Sandra Day O'Connor, our justice, former, deceased justice, she retired in 2006 from the US Supreme Court. And she spent her post Supreme Court career working against electing judges, even though she had been elected at one point in her career in Arizona. So she spent her career against electing judges. But Linda Greenhouse believes that, and maybe it's worth considering, that electing judges is okay because there can be no gerrymandering. It's a statewide race. So if you have a state where there's gerrymandering going on, the only people who can fix that are the judges, because the US Supreme Court has said it's too political to do gerrymandering issues. They're not considered by it. They stay in the states. They don't go to the federal system. So Linda Greenhouse's point is that you can't gerrymander a Supreme Court race. So you're voting for a Supreme Court judge who can deal with, if there's gerrymandering in their state, and something tells me there's been some gerrymandering lately, the judges can deal with it. She finds that to be a very important consideration in favor of judicial elections. Okay, now we know some cons, other than campaign financing, which we'll get to, as I said. Oh, I better hurry up. So the cons: threats to judicial independence. Nobody pays attention. Nobody knows anything about the judges. They just pick an Irish name. What does that give you? It's just not a good system. Okay, and move faster. Okay, financing judicial elections. This is probably the one that's in most people's mind to be the biggest detriment to judicial elections. So I'm going to go quickly. Massey Energy in West Virginia. Massey got a big judgment against them. The CEO found a guy to run for Supreme Court judge who had no experience and put out all these ads saying the judge was a soft on crime. That seems to be the big thing, soft on crime. And so the CEO's guy won, and he knocked down the judgment against Massey. It actually went up to, it had a long history, which I won't go into. State Farm in Illinois, big judgment against State Farm, I think in the billions. And it was a big race between two Illinois Supreme Court candidates. One publicized as soft on crime, he lost. The guy that State Farm wanted won, and he didn't recuse himself. So that's another issue we're going to talk about next time, recusal. And a death penalty case where one judge in Tennessee was viewed as too soft on the death penalty, and she lost. And then we have the Iowa Supreme Court, where 3 Iowa Supreme Court judges who were up for retention decided not to campaign. Groups campaign on their behalf. They had ruled in favor of gay marriage. So groups against gay marriage spent $800,000 against them. They didn't campaign. Friends or other groups spent $200,000 on them, and they all lost their jobs. There's a Michigan example. Justice Elizabeth Clement in 2018. She was a recently appointed Republican who was running for a full term, and there was a case about redistricting reform measures. And this is according to the Brennan Center, which may or may not be true. Republican Party activists told her, kill the measure or lose their support. She ruled with the majority to allow redistricting reform to go before the voters, and the party followed through on its threat and spent $800,000 to support her fellow Republican who voted the other way in that case. And they gave her $75,000 and left her name off campaign materials. Now, she held her seat though. So the threat is clear if people spend a lot of money. And of course, now we have Wisconsin. We all know, we may all know about Wisconsin and the most expensive judicial race ever. It got lots of national media. $100 million was spent on that case. I mean, just think what we could do with money like that for other things. Oh man, I mean, really, just think schools. I mean, infrastructure, everything. It's just, okay. I just wonder how the Wisconsin voters reacted to all that money spent and thinking about all they could have spent it on instead. So anyway, those races are nonpartisan, by the way, the Wisconsin, like a nonpartisan race. And I think I saw quotes as it's nonpartisan, but nobody was fooled. So, okay, now let's see. Oh, okay. Now we're going to see some, I think she said it happens automatically. Let's see, maybe not.
Vote Justice Kyra
We're going to watch some ads
for Michigan Supreme Court on the nonpartisan.
Hey, did you forget something? You have to vote the nonpartisan section of the ballot to vote for Justice Kyra Harris Bolden and Kimberly Ann Thomas, the most qualified candidates for Michigan Supreme Court, decades of experience in the law and public service.
Oh, I remember. Fairness, experience, and integrity.
Well, get that pen out. Voting straight ticket is not enough.
I think it goes to the next one automatically, she said. Click it. Okay. The clicker? Okay. Is that the clicker? Which is the clicker? This one. Okay.
Decisions of the Michigan Supreme Court impact nearly every aspect of our lives and freedoms. Justice Kyra Harris Bolden and Kimberly Ann Thomas are asking you to exercise your right to vote, to put their decades of experience to work, promoting equal justice for all, deciding each case fairly and impartially, and bringing integrity to our justice system. The Michigan Supreme Court is the last word on our rights and freedoms. Vote Justice Kyra Harris Bolden and Kimberly Ann Thomas on the nonpartisan section of the ballot.
Justice Kyra Harris Bolden and Kimberly Ann Thomas are the only choice for Michigan Supreme Court. Bolden, a seasoned justice and legal scholar with a track record of fairness and integrity, a justice for generations. Thomas, a legal expert, U of M law professor with 25 years experience as a litigator and working with kids in the court system, both dedicated to equal justice for all. Experience, integrity, fairness. Vote Justice Kyra Harris Bolden and Kimberly Ann Thomas for Michigan Supreme Court on the nonpartisan section of the ballot.
Okay, I have the information on what the candidates spent for those ads. I have that all, but for some reason it's not showing up here, and I'll put it in the handout so you can see what that costs the candidates. And I'm not sure where who donated to them or anything, but I'll give you more information next time. So finally, in like 2 minutes, these are possible solutions to the elected versus appointed. An accountable appointment system. I mean, I think that's one of the complaints about appointments, that you don't really know who's appointing, you don't know how it's done, and you don't know who they're looking at. Strengthen recusal rules. We'll get into that next time. And have judicial public financing. Now, I looked into judicial public financing a bit, and 2 states have it right now. At least they had it in 2018. Maybe they don't have it now. New Mexico and West Virginia. Wisconsin actually had it at one point, but it went broke. I mean, it's really hard. They tried checkoffs or using money from fines or vanity license plates. I mean, it's expensive. You don't know who should get the public funds, which candidates, only serious candidates or any candidates. What happens when other people they can't keep other people from giving funding, private funds to one person and one person committing to just taking public funds. So it's really complicated. What I read didn't give me a lot of hope for it, although one article says you got to be hopeful. Anyway, there's a lot more. There is so much to be said on these issues, and I hope I didn't spend too much time on all the background and trying to personalize the judges. Next time, we're going to get into, judicial independence, judicial behavior, conduct, impeachment, recusal, and politicization. So I guess it's time for questions. I didn't give you much time for questions.
Well, thank you very much for the important civics lesson today.
Yeah, I hope it's okay. I hope everybody likes civics. I don't know.
Yeah, I'm still, my head is, I'm trying to get wrapped around the idea that a circuit court candidate from Allegan needed 600 signatures and a Cook County candidate needed only 500. I know different states, different
Well, it was a
jurisdictions, different
sub-circuit.
time.
Yeah.
Yeah. But gerrymandering, wow,
Yeah.
it's crazy to me.
Yeah.
But I'm just curious, it was quite surprising to me to see the makeup, the religious declaration of the Supreme Court of the United States. And, the Michigan Supreme Court, I'm curious if you have any information about any declared religious affiliation of the justices for Michigan Supreme Court. Thank you.
I didn't look into that. I'm not sure that it would be there. I did look at their biographies online, just briefly. I just kind of skimmed through them. So I didn't notice one way or the other. I wasn't looking for that, but it may be public information. I'm not sure. And yeah, it's a good question. I'll let you know for next time. Okay.
Yes, Judge Kennedy, can I ask you a question? This may be totally inappropriate, so if I get thrown out of the room, that's okay. But there has been a case in the last couple of days where the quote fake electors were declared that they just did not have education enough to understand what they were doing. However, one of the electors chartered a fleet of buses, just one obscure day, let me daydream him, January 6th, 2021, and she only ran the Detroit-Washington run. That was the only route she had, and she only ran that day, but she apparently had no idea what was going on in Washington that day, per the judge in Michigan. What
You want to comment?
No, I don't want to comment, but I'd like next week for you to say, it seems to me that since the whole case was based on the lack of knowledge by these innocent, less educated people, and that's why they got off, because they were innocent, less educated.
So I think the thing is that, I think what you always have to keep in mind is that we weren't there hearing the facts. We weren't there deciding which facts were true. And when you read a report of a case, any case, it comes to you as this is the truth. This is what the court said, the court guilty, innocent, whatever. And we weren't there to hear what was said, to understand how the law was applied to the facts. So, it can sound, things can, you have to be there. And, and I think, and you can live stream. I forgot, I'm going to put this in my, you can live stream a lot of things and watch. And in fact, in the old days, and I know there's another question, in the old days, there were court watchers at the Dirksen Center in Chicago. Usually little old men, they'd gather in the lobby and they'd say, hey, who's doing an interesting case today? And they'd go up and watch the cases. So now we can watch it online. So you can watch the judges in action. You can see what they're doing. And again, I just have to reiterate, things can sound one way, but if you're the trier of fact, and later on, I'm going to give my plug for jury duty when you do this, you decide what the facts are. You decide what's true. So could have been, yeah.
Judge.
No.
Judge Kennedy, there are age limits, for example, air traffic controllers
Right.
at 57. pilots, there used to be 60, 65 now. And you said like for judges, 70 seemed young. I'm not so concerned about their mental capacity, but obviously opinions, it's not just applying the law, or we would have a formula, right? I mean, opinions matter. Somebody like the judge that you were mentioning is 98, or I think Judge Stevens was 99. Somebody born in the 1920s making decisions for people who will be around in 2100. Doesn't that seem there should be a limit?
Yeah, well, I think that's one of the concerns, that without limits, they're in ivory towers. They don't know what's going on, or they just don't care to find out. But I don't know. I don't know. I have a friend, she's 82. She's working actively on the federal court. She's great. So I don't know. I think it's individual, and they do have to do mental and physical report checks. So their opinions. Oh, okay. Just to finish that. So I think we all have opinions, and they're there, and they change over time, or they don't change, or we don't grow. We're stagnant, and they are who they are. And maybe they do, maybe they don't. I think it's too individualized to really determine that a certain age, you're not going to be growing or flexible or thinking things through and thinking how it would apply in 2100 or whatever.
You mentioned that we could live stream, but is there written?
All their cases?
Yeah.
Oh, yes,
So
they're all
like
available.
This one that we're just talking about.
Yes,
We
I
could
mean,
get
I
those
don't
transcripts.
remember what level it was. Was it federal court? I didn't. State Supreme Court? Yes, that would be a ruling, a written ruling of the state Supreme Court if I'm,
Well, I mean, like,
a single judge. Oh,
but would it be
I-
for the whole trial? Would those
the whole
not-
trial.
Would those
I-
transcripts be available?
I'm not sure. Let me get a good answer for that
Okay.
for next time.
All right, thank you.
I actually was too busy preparing for this to know what was happening in the world yesterday. So oh, yes, I think they are. Oh, definitely. I mean, I think, the question is, are people losing respect for the court system? I mean, that's what the pollers say. They've lost, 70% positive in 2020 of the Supreme Court, and 50% in 2025. So it's going, at least the US Supreme Court is going down. Now, the polls that I looked at, which was a very small one, said state court is healthy and fine, and it was 63%, which I guess is good. Confidence.
I used to think that courts moved slowly, but in today's environment, it seems like you're getting an opinion of a federal judge in California and then somebody else in New York, and it almost seems so chaotic.
Yeah.
And then you have the Supreme Court, which I always thought was like the last word, giving these emergency opinions without any explanation for what's going on. It's almost too much for an individual to comprehend.
I know exactly what you mean. And I do plan to touch on the shadow docket next week and sort of go into what's going on. I mean, I think there is a way to move quickly. Sometimes there are emergencies and you can move quickly and you don't have the full briefing or the full hearing, preliminary injunctions and temporary restraining orders. You can move quickly. You can work really hard, stay up all night and get things done. But I think it's the moving parts. It doesn't, I know exactly what you mean. I'll try to address it a little bit next time, because I think it's a concern for many of us, just because we want to figure out what's going on. We want to figure out why they're deciding what they're deciding and why they're, I think one of the most disturbing things, which I'll talk about next week too, was the rebuke that an 84-year-old judge was rebuked by the US Supreme Court. The US Supreme Court said he wasn't following their precedent, their recent shadow docket precedent. We'll get into that next time.
It's my understanding that the people who spend the most money usually win in an election historically. I don't have the exact figure, but that's in my mind, that the people who spend the most money. And a lot of the money is spent on advertising, whether or not it's social media, radio, and TV.
Right.
I'm wondering, we're looking at solutions. Is it possible to have a non-partisan, unbiased committee that has to approve the ad before it gets shown? Meaning both parties have to say that is a true statement. Because I see things on TV back to back, opposites. They say the exact same thing, but they're the opposite of what the next person that I just saw 30 seconds ago. And I'm wondering if there could be an independent group that says before anything gets aired, and I realize that'd be hard on social media, but on radio and TV, you could have this independent group that that ad is approved by all 5 of these people because what we've back checked, those are true statements. That would be a potential moving in the right direction.
It sounds good. I think free speech might come in the way of that. It's pretty strong but I don't know. I'll think about that too for next time.
I'm a bit of a podcast junkie, so I'm kind of interested in whether or not you follow any legal podcasts. You don't have to list them now if you do, but if you could provide that in one of
Yes.
your updated. But are you a podcast listener?
No, I'm not, because I hate the commercials. I can't deal with the commercials. I just can't.
You just
I
forward.
know
through them.
that's what my kids told me, but if I'm in the car, I just can't. Anyway, but I have friends who are, and I will get them.
Okay.
She's already given me a couple.
Strict
So-
scrutiny? Okay, thank you.
Pardon? Yeah.
Over here.
I'm interested in how judges keep their personal opinions, their personal beliefs, their personal religious beliefs, social beliefs out of their process as they're making decisions.
All right. So that's a really good last question. I think it could be the last question. I think I'm just going to say that if you're on a jury, you would have the same consideration. So we all have our beliefs, our thoughts, our everything. And this is who we are. This is what we bring to our determination of what the facts are and how the law applies to the facts. So we try to, I don't know, distance ourselves from them, sort of. If you can, maybe you really can't. You just try to do your best. And if you've ever been a juror, you try to do your best to listen and to just judge the credibility of the witness, listen to the arguments, and just not think about, ooh, I didn't really like how they looked. You just gotta try to. I'm just gonna say I worried sometimes when I was a judge that some really shy person, and a lot of them didn't have lawyers, they would just represent themselves. Just a really shy person wouldn't be able to, convey what they wanted to say. And I might think they weren't credible. Because they couldn't put words together or they didn't seem smart, so you just gotta kind of just take it all down and just try to be open to it and do your best. You just have to do your best. Okay, thank you very much.
Thank you again. See you next week.
Too nervous.
Represent Cook County.
Where? At the juvenile court?